Right. Welcome back, everybody. We'll leap straight back into it. Before lunch, we had been dealing with this question that had been raised by Fourth Ports about conditions, and I said I'd come back to the council after lunch for a response to that point.
Thank you, Ron. The first part was just a point of clarification. Mr. Owen made reference to the White Sands flood protection scheme that one of his colleagues was involved in. And that's a slightly different situation to the one we're in today, in the sense that that was a flood protection scheme that was called in by the Scottish ministers, whereby they were making a decision on confirmation of the scheme and Dean's planning permission. Really, depending on the outcome of the report, the council will make a decision on the confirmation scheme, but the issue of Dean's planning will be one for the Scottish ministers. Now, if you feel that the condition is required to address a matter that's been raised by Fourth Ports or any other party for that matter, then it is our position that it would be open to you to make a recommendation in your report, or include a comment in your report on that matter. But ultimately, it's something that the council can make a decision on. That would be a matter for the Scottish ministers subsequently, if the council makes a decision to confirm the scheme. On the content of conditions, the council just wanted to state his position clearly that it does not consider it appropriate to have conditions where third-party approval is required to satisfy a discharge condition. Now, we also understand it's not generally these days practice to also include explicit requirements requiring consultation with third parties. But the council had a strong feeling that that was something that was felt necessary to include in the conditions. Now, another point just relating to conditions is that we also know that Fourth Ports obviously have the protection of the Section 56 as Section 58 as a statutory undertaker, whereby nothing can be done to interfere with their undertaking without their consent. Now, there is clear and explicit protection for Fourth Ports built into the legislative regime on that basis, and the council would hope that that consent can be secured by way of the agreement that both parties have talked about earlier today. And also a matter for Fourth Ports themselves, that agreement such matters may be a more appropriate form for doing such matters, given the sensitivity of some of the infrastructure that the Fourth Ports have, rather than a public forum of conditions. But that's a matter for them, of course.
Thank you. Is there anything you want to come back on, Mr. Lee?
Just a few things. It's entirely correct that White Sands was a public inquiry held following a calling of the scheme concerned. We don't think that makes any difference, though, to the point of principle we're making, which is that there should be available for all relevant interests, not just Fourth Ports, to see and to comment on at this stage what are the conditions to the direction as to deemed planning permission that the council would wish to see, would propose. We understand, and it's entirely accepted that if the scheme is confirmed by the council, it'll be for the Scottish ministers to give the directions to deemed planning permission. There's no dispute there. Nevertheless, it would be entirely normal in a case like this where you need that government authorisation under Section 57 of the Town and Country Planning Act for the scheme promoter, in this case Falkirk Council, to come forward with conditions. And I refer you to the fact that in their response to our written statement, they say in 10.2 the council agrees that appropriate controls must secure both design flexibility and protection of port operations. Then goes on to say that Fourth Ports haven't set out the nature of the conditions, and as I said earlier, that's not really for us to do. But this isn't just an issue for Fourth Ports. This is and yes, there is protection for Fourth Ports under Section 58 of the Flood Act. This is a matter of general public importance and interest for the whole of this scheme, in terms of what are the conditions to secure these the detailed design and necessary mitigation, including during construction. And we just don't know, because they haven't been put forward, and that is, we say, a major flaw, a major deficiency, because it's absolutely relevant to determining the acceptability of the scheme to understand what are going to be the planning controls, and there clearly will be planning controls as Section 57 envisages. So and we're also I mean, I do a lot of work on government planning directions, and they often do provide for third parties to be consulted before the relevant condition is discharged. I accept what Mr. McMurray says about third parties not being a discharging authority, but certainly they can be and normally are consulted before a condition is discharged by normally the local authority. So we're not asking to be the discharging authority, we're just asking to see now at this stage, before the council decides whether to confirm the scheme, what are the conditions that it would then be suggesting to Scottish ministers should be imposed on the scheme, and we're wanting to see those so we can comment on them and understand whether we might be involved in some of them in terms of being a consultee. So that's the point. And yes, we have section 58, but that's not the answer to the lack of any draft planning conditions.
Yes, thank you, Mark. It's a matter for you, but I would note draft conditions are in preparation, and if you felt it would be helpful and appropriate and necessary, what could be done was that those draft conditions, once finalised, could be circulated among the parties for comment, and then could form part of your report at that point.
Thank you. I think I'm going to leave that there because it is a point that wasn't brought up in the original hearing statement, particularly the detail of all planning permissions. I don't think we put that up in there.
We did cover it in section 4 of our written statement, ma'am. Section 4, particularly section 4.5 and 4.6 and 4.7.
Okay, thank you. Well, I've heard those points. I'll go away and concentrate on that, I think. And if I want to pick up on that issue of circulating of conditions, I'll make sure that everybody knows that and people have an opportunity to comment. But I'm not prejudging that at the moment. I want to go and think about that. Thank you. If we could move then to the last area of scheme design, which is in Shire Road, and I'm thinking we could probably deal with that fairly rapidly. So there was an objection there which related to the proposed position of the flood defence in relation to a gas pipeline, and the objector was going to participate, isn't participating, but I understand that's probably on the basis of discussion, but I don't know whether there's any update that the council feel I should be aware of.
No, that there hasn't been any other discussions with the objector. Whether the objectors reflected on what we said before, but I think our position is that the situation that they raised with the potential conflict between the flood defence wall and their pipeline is in many ways no different to how we deal with Scottish Water or Scottish Power or Scottish Gas networks. There is a multitude of clashes with existing utilities, and there is provision within the scheme for the diversion or protection of those, and that will be subject to kind of further discussion and agreement with the in that case statutory undertakers. But whilst the objective is a statutory undertaker themselves, I think the view is that we would be treating them on the same basis, and it would be reckless of the council to proceed with just trying to construct a flood defence wall that we know is going to interact in places with a gas pipe. But that's just the point we tried to make, is that just wouldn't, if that's not going to happen, any agreement to what's required in terms of protection or movement of that pipe is going to have to be done with the objector, and council accepted that the cost of that is something that they would bear as part of the scheme costs. I think there was offers of further meetings with the objector, but no further meetings have taken place.
Okay, thank you. I believe that brings us to the end of the detailed design matters, but I'll just pause before we move on to item 3 in case there's anything else that people feel violently that they want to bring up at this point. So item 3 is construction effects, including timescales and so on. And I'm going to start with a few, again, generic questions to the council, just so that I am clear on the situation. So in a generic way, and this probably harks back to our discussion about conditions, about how is it anticipated that disturbance, particularly from noise and vibration during construction, is going to be managed?
Sorry, I was on, put myself off there. Yeah, I think in terms of the disturbance, there's and from noise, there's a variety of I suppose ways that will be dealt with during the construction phase, whether that's through limiting the construction hours in certain places, which we have confirmed to a number of objectors that I think the council's kind of normal rules in construction work allow construction, I think, from 8 AM to 7 PM at night and on Saturdays, and we've confirmed that we would limit it to 8 till 6 Monday to Friday. But there's other measures that would be taken, I suppose, more locally, and whether that's the choice of equipment that's used. There will be contractual constraints on those that are employed to construct the scheme to stay within certain kind of noise limits and to implement various kind of mitigation to reduce noise as far as possible. But at the same time, we are talking about fairly major civil engineering construction that is in people's back gardens, so there's going to be there's a level of disturbance that we can't avoid altogether, but it's certainly planned to put in measures, and we certainly see that kind of mitigation as something that would be implemented through planning conditions to secure that mitigation occurs.
Yes, I hear what you said there about the limiting hours. Obviously, in a number of the objections, people have identified that they work from home, which of course has been an increasing thing since COVID. So is there any additional measures, I don't know, that could be considered past the disruption elements?
It's kind of difficult to see, each one's almost a kind of unique kind of situation, but I expect noise is going to be a kind of key factor for majority of people in terms of disturbance, and I say there's going to be mitigation put in to reduce that as far as possible, but we'll never be able to get into the situation that we can construct something completely silently that's not going to result in any noise. So I think it's it's through those kind of mitigations, the working hours, and trying to ensure that we complete works within a specific area as quickly as we can and move on, such that we're not in someone's back garden for a prolonged period of time.
And just on that point, we've had hinted at sort of a long duration for the implementation of the scheme. Are you able to give any kind of indication of sort of how long it takes to build different sections, I suppose?
Yeah, I think it's kind of difficult one to be very precise, because the fences in each area vary. Some of the fences are quite simple in terms of construction, and that probably affects most of the kind of mainly the industrial areas, but we have just sheet pile walls as the flood defence, whereas when you go into residential areas, we've got sheet piles with concrete surrounds with brick or stone cladding. So the kind of timescale for constructing, even a flood defence of the same height can vary depending on the other works that are needed, which is largely dependent on where where the defences are located. I think we did indicate there was obviously quite a few objections from the kind of Waters End area along the Chapel Burn. I think we envisaged that overall kind of section could take 12 months to complete. But again, we did highlight that that's not necessarily kind of 12 months at the same location along that stretch. Your works would progress possibly from one end to the other, but you could start both ends and kind of work towards the middle. But those types of decisions on the precise kind of sequencing, have not been at this stage. We've not been precise, and we'll have two different squads picking from either end, but it's difficult, but precise, just kind of precise kind of timeline to, because it will depend on area by area and other issues such as how easy it is to access areas and get plant equipment in and out.
Picking up on sort of further points that have been raised, then obviously there's been concern raised in a number of the objections about effective piling. Actually, some structures will involve piling. You able to just explain how that concern about damage and so on is dealt with as part of the scheme?
Yeah, so I think in response to kind of objections that raised that point, whilst I think the majority of our defences have piles associated with them, the risk of damage to property relates to many factors, including like how close the defences are to those properties, the ground conditions that we're installing the piles through, and the method of installation of piles. I think in most, there's not many locations I can think of where we're very close to properties, and that in Belts we don't have that situation as part of this scheme. Building flood defence to properties does occur. There's many examples of that, and we've been involved in schemes where we've built flood defences, probably less than a metre away from tenement buildings in Glasgow, which are very sensitive to vibration. So there is techniques available, and those techniques for each area, or the technique to install piles in each area, will be assessed on a area basis. But it's obviously not in the council's interest to be proposing methods of installation that's going to cause damage to property. So that's it is something that will be assessed again as part of the detailed design, and there will be, I would expect there to be contractual limitations or specifications on the methods of installation, and also on the control of vibration levels that are measured during the construction, so that action can be taken if the actual vibration that's being caused was to exceed or approach the limits that were specified.
I just add to that now. This is a topic that was raised by a few attendees at the public exhibitions that we held before notification. We said then, and we still say, is that as part of that process, Alan alluded to those monitoring that would include surveys of the property before and after the construction. And in the unlikely event that there had been any damage, then there would be mechanism in place to compensate and to repair and compensate the relevant parties.
If I can move then to some of the areas that would be disrupted, and those people we've got here before me today. So Mr. Galt, I think you mentioned already this morning your concerns for yourselves or your organisation about the disruption during construction.
Yeah. One, I think so. But yes, yeah, we've concerns. Over the limited yard use that you would receive. Thank you.
And do you have a feel for how long that disruption might occur?
No, again, I'm quite hoping that's something that could be established today.
The council, I don't want to put you on the spot, but I don't know if we've got rough ideas of timelines.
I think as Alan alluded to, you know, each area of the scheme is going to have different limiting factors on how long construction periods are likely to take, and depending on the construction techniques, the available access arrangements, and the type and the depth of piles that are to be put in, and also the finishes on the wall, whatever that may be. I think the Jarvie plant is one of the more simple finishes on the wall, but certainly the depth of the piles may be a limiting factor on the type of plant that's required and the duration to do that. But Alan maybe be able to give us a bit of a broad indication in terms of a kilometre of defences may take.
Yeah, I think in almost going back to what the point that we made this morning about how we would try and minimise disruption through doing the works in phases. Now that would obviously, you know, if looking at two examples, one would be we were given the whole of the space within Jarvie plant with no constraints on it, so we'd full access on day one. You know, the construction period for that length of wall would be shorter than if we have to construct it in, say, 5, 6, 7 phases. You know, that would take longer. So I think in terms of, you know, what it would actually be, it's kind of largely going to be dependent on what's agreed in terms of that kind of phased approach, because the more phases we have, the longer it's going to take. Is that a better approach than having a shorter period of time where we just have access and can do the work as quickly as possible? I think Mr. William, I think you mentioned, or someone mentioned this morning, it was about 450 metres long, the kind of length of the fence there, and given as Mr. Dawson said that the form of construction there is one of the kind of simpler, it's basically sheet piles that are driven and cut off at the kind of appropriate level, that there's not concrete works following on or anything. That, you know, I would have thought, you know, that would be somewhere between, you know, 3 and 6 months that could be done within. But I say it really depends on any other constraints that are applied, because often there's many constraints about that would limit work, whether that's some of the environmental mitigation or we would have to kind of take everything into account. But I'm not aware of anything that I can think of there. So yeah, I would have thought that would be a kind of reasonable time scale.
So that's one of the things that will be sorted out after the scheme is confirmed, if it's confirmed, one of these details that we're talking about this morning.
Yeah, I think that planning for how we're actually going to carry out the work, and whether it's better to split it into phases and do a kind of, you know, work in, I don't know, say a 50-metre length, finish that, then work in the next 50-metre length, and then gradually work your way along. Whether that's better than just saying, well, we'll disrupt you for, you know, you'll lose access to that strip of land for 3 months, but we can do it all within that period. Whereas if we do it in a phased approach, maybe it would take 6 months. So I'm kind of guessing about those figures, but I think that's something we'd have to discuss with Jarvie Plant to see what's the overall, you know, considering everything, what's the least impact on their business.
We wanted to come in, St. Johnson.
Yes, sorry, thank you. I was just going to add to that. I mean, I think it would be largely sensible and typical in most construction projects when there is going to be those impacts to involve the contractors that will be involved in doing that in that discussion. So as part of that detailed design process, council would propose to engage early with a contractor and to look at those considerations and those opportunities, whether it's restricted access, whether it's concerns over the hours of working, and whether it's the mitigation measures that need to be provided for the likes of Jarvie plant during that construction phase, and to consider the alternative approaches and come to the best compromise, bearing in mind all those considerations.
Thank you. So I think you illustrated to me this morning, Mr. Gold, that you would look for alternative land to help you operate during that time. Is that correct?
Yes, yeah.
And is there anything else that you want to come back on, having heard that discussion?
No, I think
Council?
that covers most of the points.
Thank you. Could I turn now to both ports? And I think the effect of construction activity was your key issue 5 in your hearing statement. And you've also given me more information about this in paragraph 6.2 of the hearing statement. You talked in there about needing an agreement with the council. So I wonder whether you wanted to just sort of elaborate a little bit more about your concerns during construction. We've heard some element of that this morning in relation to the gates on the lock, but I don't know if there are other aspects you wanted to highlight today.
Ma'am, thank you. I think the overriding point is there is really a substantial amount of work to be done to come up with an acceptable arrangement to the port for construction of the scheme that will be secured by a legal agreement between the council and the port. Operating ports are complex environments, as you can probably appreciate, and perhaps Mr. Knox can just highlight some of the issues that are a concern to deal with in a construction agreement.
Yeah, I think there's a number, and it's Mr. Owens confirmed, most quite complex environments in terms of the activity that's going on, notwithstanding the fact that Grangemouth is of significance in terms of its importance to Scotland. We've got Scotland's fuel supply effectively moving through our facility, where Scotland's largest container port, so a lot of Scotland's export trade, which is critical in terms of some of the services providing to the world, goes through our port as well. And there's peaks and troughs in terms of levels of activity there. So understanding a bit more detail around parameters around constructability is important, because trade flows do move up and down, as do traffic activity levels in the port move up and down. And equally, we've got security considerations that we need to play into our thinking around how activities are managed in the port estate as well. And that's just probably from an internal kind of movement point of view in cargo. I think it's actually become more complicated and nuanced when you actually look at a lot of gate infrastructure, given one point of entry, one point of exit for vessels that arrive at the port, and significant periods of disruption can cause significant impacts, particularly in relation to fuel supply into Scotland. And the parameters around those have kind of changed somewhat recently, given recent local announcements about the refinery, where there was an export flow that moved out previously. It's all import flows now. So in terms of supply chain resilience, the importance of the lock gates in particular being operational cannot be underestimated. So that'll be a main focal point for us.
If I can just supplement that, ma'am, by just emphasising the point that Forth Ports Limited obviously is a business and wishes to look after that, those commercial interests. But in this context, first and foremost, it is a statutory harbour authority, and it has various duties in relation to the safe and efficient functioning of the port owed to all users in effect, and those are set out in something called the Ports and Marine Facilities Safety Code, which includes a duty to ensure safe and efficient marine operations. So that is why it's critical that the port knows what's going on within its environment and can control it. And having lots of construction activity clearly presents all number of issues that will take a lot to work through. And we welcome what we've heard this morning from the council was in the context of design, but I think the same sentiment applies. But there is a considerable amount of work to be done to get to a position where the construction controls are understood, and some of them will overlap with planning conditions, which is why I've been talking about that earlier. So that in a nutshell. Well, there is more detail in section 9 of the objection, but I hope that suffices for now.
Just wanted to follow up, I think in paragraph 6.2 of your hearing statement, and when you're suggesting that there's a need to be a bespoke legal agreement, and whether there was a particular format, you feel that there is a structure, a way, a mechanism for achieving what you feel is necessary.
Well, I think the sort of hook for that is the provisions of section 58 we've been talking about of the Act. That and the preceding sections don't lay down a procedure as such for the council and the port to operate together to end up with an agreement, but because of what section 58 says, that in effect the port needs to agree to works being carried out, then it's obviously in the council's interest to try and progress those discussions as quickly as possible. There are all number of precedents for these sort of situations that can be drawn from. I'm not particularly referring to flood prevention schemes now, but where major infrastructure projects are built in and affecting ports. I dealt with one recently in Suffolk in England, a major bridge built over part of the port of Lowestoft. So there are lots of examples recently where complex agreements have been entered into dealing with just these sort of interfaces. So a lot of learning to be drawn from is what I'm saying.
Thank you. Council's point of view, do you want to respond to that, particularly in terms of mechanisms for and so on?
I'll make sense to myself. Thank you, Mel. I don't think there's any difference between the parties here. I agree with the points made by both Mr. O'Rourke and Mr. Knox that there is a need to progress this agreement in these circumstances, and I agree that section 58 is the relevant framework within that. I myself have also been personally involved in similar agreements with port authorities for complex infrastructure projects and active and operational ports. So again, there is, I think, learning on both sides that can be drawn from. And I also agree with Mr. O'Rourke's points that these agreements can be complex and they will take some time to work through the detail, but there is a route through to achieving these things. And as what Mr. Dawson was to support it.
Thank you. Does anyone want to add in anything else about construction effects before we move on? Okay, thank you. We're going to move to item 4 then, which is linked. First of all, we're going to consider loss of trees and effects of this on privacy, security, wildlife and amenity. And we spent a bit of time this morning talking about the specific situation at Zetland Park, and I feel I'm comfortable with understanding what the situation is there. I really, I suppose, want to broaden that discussion out a little bit more broadly to pick up on some of the objections that were raised. And this, again, is primarily questions for the council. So can you just sort of summarise for me, I suppose, the general approach that's been taken in respect of trees particularly and other vegetation in terms of what can be saved, what can't be saved, and how that approach has been dealt with?
Yeah, I think in general, as I mentioned, this morning, we haven't set out a strategy to just remove trees. So the trees were one of the considerations in terms of looking at alignment of flood defences along with various other considerations. And really where trees have been identified for that, or we believe will need to be removed, or any vegetation, it's because we don't believe there's an alternative alignment that's that's better. We could have taking again, it was an issue that was raised by quite a few objectors in the kind of Waters End area, and I suppose you could say, well, the alternative would be we'll build the flood defence 1 metre off the back of your house so that we can keep all the trees on the riverbank. But would that really be a better option. What we've tried to do there is, we appreciate the importance of people's private space, their gardens, and we sought to construct the flood defences that we weren't kind of reducing the usable area of people's gardens. I know some of the objectors raised questions over what land they specifically own, but we looked at position of existing boundary fences and gardens, and we tried to ensure that the scheme wasn't in the long term going to reduce the available space people had in their gardens. And what you tend to find is a lot of the trees, except for Zetland Park and probably some of the other parks, but and I suppose one or two trees within gardens, but the majority of trees that we're affecting are trees that weren't planted. They're kind of self-seeded, over time. They've grown there, and it's just that balance that would it be better to half someone's garden in size and keep the tree on the riverbank, or maintain their garden? And unfortunately, again, just with the fact that this is kind of major civil engineering works, the fact that a wall might only be a metre above ground, the flood defences are constructed quite differently to your kind of typical boundary wall within a garden that have very shallow foundations. Kind of structurally, they aren't kind of significant, but we're dealing with flood defences that have to deal with both the kind of pressure from the water that they're retaining. We have to ensure there's not a risk of water getting underneath the wall through the soils and still flooding the areas that we're trying to protect. So they are substantial structures which need large construction plan to install them, and that plan needs space to operate. We need space to get the equipment in, the materials in, and unfortunately, in certain areas, the trees will need to be felled to allow that to happen. But we've tried to minimise it where possible, but that's not going to be possible in every area. There's trees that will have to be removed, and we haven't kind of tried to hide away from that. The scheme plans, as you'll have seen, can identify the areas of vegetation that we believe will need to be removed. But even during the construction phase, we will still be trying to maintain where we can. And some of these trees might not exist when we come to construct the scheme anyway, but
and you mentioned this morning, I believe, that in Zetland Park there was a policy of replacement of 1-to-1 for the watershed. Am I correct in remembering you said a replacement policy of 3-to-1 elsewhere is possible? So I suppose I've got a question. The replacement, it's like two areas, if you like. There's the public spaces along the riverbank, and then obviously there's the private garden spaces, and just an understanding of how the restoration of vegetation can be dealt with perhaps differently between those two areas.
Yeah, I think you're correct. In the likes of Zetland Park and other areas like Grangemouth Park, where there is avenues of large trees, the proposal there is to plant large trees. I think we've kind of quoted kind of 3 to 5 metres in height. So in those locations with that type of planting, you wouldn't necessarily plant 3 trees for everyone, because you're planting kind of quite large specimens. Overall, we're trying to ensure that you plant 3 trees for everyone that's removed. But you're correct in terms of kind of private gardens. The approach to replacement vegetation there is going to be, it's going to vary basically property to property. And again, that's something that we see would be agreed with individual property owners. Having kind of worked on many of these, many similar schemes, the approach even that the property owner wishes to take will vary. You have some people who want to do their own reinstatement, so basically just be compensated, and they will do the kind of replacement planting, or within private gardens quite often that will extend to patios and decking and kind of various things like that. And that's certainly, if that's what a property owner wanted to do, that's something that we would, we would prevent that happening. Whereas there's other owners who, don't want anything really or they don't want to get into that level of detail. They basically, they know they had slabs patio in an area of grass and they want the council to put that back. Similar with vegetation as well. And yeah, it's really done on a case by case basis, but ultimately we would be, before we access any of these areas to construct it, we would be doing kind of a survey or a joint survey with the property owner of each garden to establish what's there just now and what areas are going to be affected. And then hopefully at that stage reach agreement, although if someone wants to change their mind later on, that's fine, but it's agreeing on a garden by garden basis how that's going to be reinstated. And I say experience is that will vary. One garden will want something in the garden, the property next to it might want to do something different. But ultimately, I suppose the aim is to ensure that all those residents that are affected are content with either what's returned to them if the council are responsible for doing the work, or they feel that they've received fair compensation. We'll get into compensation if they choose to do the work themselves.
Thank you. And then just a final point, obviously, where you're working next to private gardens, there needs to be removal of existing boundary features, which includes vegetation, and people have raised concerns about security during the construction period because of the removal. Are there any comments you're able to provide about that?
Yeah, I think the boundary between the construction works and because if taking Chapel Burn as an example, typically the boundary fence for people's rear gardens is at the top of the riverbank. And our flood defence wall, I think in most locations is either just off that boundary or I think in some locations it's on the boundary. But to construct that, you'll need to take down that existing fence and occupy part of the garden. Now that kind of temporary boundary between effectively what's the construction site and the garden, I would envisage, is going to have a minimum 2 metre high secure fence along there. Probably again, in kind of experience of projects, probably something more robust than your kind of terrace, metal kind of fence panels that you see. It's probably some kind of timber hoarding would be installed along that boundary to replace the existing fence that's there with something of similar heights. And obviously, the construction site itself would be fenced off to prevent unauthorised access. So there would effectively be kind of 2 lines of, I suppose, defence. Someone would have to, one, get into the construction site to begin with, but then they would also they'd have to cross one fence. They would then have to cross the fence from the construction site into people's gardens. So in terms of a kind of fencing point of view, I don't think there would be any, what we're proposing would be any less secure. But there's obviously vegetation that could be removed that can't just instantly be replaced, that can add to the kind of security or privacy. But that would be replanted after the flood defences are complete. But I think there was certainly one objection that almost sounded as if there was kind of expectation that there would be nothing to delineate the construction site from the remaining part of their garden, because they talked about, I think, children being able to get into the water or into the excavation, but there would be a 2 metre high fence, the same as what is at the back of those gardens just now, to prevent that from happening.
Thank you. I think I've got sufficient on that. So I'm going to propose that we move on to item 5, which is the effects on wildlife. And I wanted to do that in 2 phases. The first phase is just to look in generic terms about habitats and species. And a number of the objections have raised concerns about habitats and species. And so it would just be helpful to have a little summary, I guess, just to summarise how effects on habitats and wildlife have been assessed.
Yes, I would just a bit of a substitution.
Yeah. I wonder whether my husband to just reintroduce yourself, because it's a long time since this morning and we haven't got the benefit of your name badge there. Oh, yes, we have it, just touch there.
Yes, Rosanna Minnie, Associate Director of Ecology. And sorry, could you just repeat your question?
Yes, can you just give me a summary? People have raised concerns about the effects on habitats and wildlife, particularly including aquatic wildlife and bats. So I'm just wanting to understand how you feel about assessing those and whether you've identified any significant effects on any habitats or species as a result.
So the biodiversity chapter of the EIA report, which is chapter 7, considered the potential impacts on habitats and wildlife. So that assessment followed Chartered Institute of Ecology and Environmental Management guidelines. And within that, we conducted a suite of ecology surveys between 2015, I think, and 2023. So sometimes we would have to do repeat surveys just because the data had gone out of date, just to make sure we've got an up-to-date baseline as the assessment progressed. Those surveys were conducted by suitably experienced ecologists, and H. Scott confirmed that they were content with the surveys that we did and that the information collected would be sufficient for our assessment. And then in terms of impacts, so any significant impacts recorded in the biodiversity chapter, we would then provide mitigation for. If there were impacts that were not deemed significant, they're not required to provide mitigation for them. But a lot of the time, the mitigation provided for significant impacts would also benefit a lot of things where there were non-significant impacts. And then there's other examples where legislation or policy or best practice guidance would also ensure that species were protected, even if there wasn't a specific negative impact identified for them.
And did you, were there any residual significant impacts on any habitats or species?
Yes, so there were two. One was related to the winching birds on the SPA, the proposed SPA. Obviously, we deal with that in the HRE assessment, so that was one of the residual impacts in the EIA work, and that acknowledges that compensation has been provided. So that is touched upon within the EIA report. Obviously, there's a lot more detail on nature in that one. And then the second residual impact was on broadleaf woodlands during both construction and operation. So that was acknowledged that would be a residual impact whilst the placement mitigation matured. So to try and speed that process up, there would be a mix of ages and sizes of trees and shrubs, etc., planted just to make that window as small as possible. But it's acknowledged that once that vegetation is sufficiently matured, there would be no residual impacts.
Thank you. You'll have probably seen in the objections there are particular concerns raised about hedgehogs and bats, and I don't know whether I would find it helpful if you just would like to add a couple of comments about how the effects on hedgehogs and bats have been assessed and what the conclusions were.
Yep. We actually had some consultation from the objector in relation to the hedgehog point early on, and off the back of that, we decided to do hedgehog surveys. It's not something that we would do as standard on these sort of projects, but we took on board their concern and we completed the surveys. survey did identify some hedgehogs in targeted locations. I think we only had them in 3 locations, and we had done surveys at 20 locations. Now, I appreciate that that's just a snapshot, and the hedgehogs are probably in more places than that. But when we put them through our assessment, it came out as a non-significant impact on the hedgehog, both at operation and construction. However, it's one of the species where I mentioned earlier, there's lots of other mitigation that we would do as standard or for other receptors that hedgehogs would benefit from. In addition to that, within our enhancement measures, we have acknowledged that replacement shelters for hedgehogs and other receptors would be beneficial, and that is to sort of add these shelters into areas of suitable habitat rather than as a replacement for suitable habitats, which really just to provide resilience in those areas. Move on to bats if we're content. For bats, so they are a European protected species. We did quite a lot of surveys for bats on the project that included predominantly ecological appraisals. We did risk assessments, we did winter hibernation inspections, activity surveys, which would be typical dusk dawn surveys, and we also did some transit surveys. So that all allowed us to get a really clear understanding of how bats are using the area. So there were some significant impacts to bats prior to mitigation, but once we added in mitigation, there's no residual impact there. And in the mitigation for bats would be some standard construction mitigation. One of the things I should say for all receptors would be that we had to do pre-construction surveys just to update the baseline, and then if there was any need for licensing requirements or any additional mitigation, that would obviously be identified at that point. And then there's various measures of construction mitigation just to minimise the risk to bats, which may include assuring appropriate people felled trees so they're aware of bats. And then be within the operational mitigation with included bat boxes to be added in for the loss of potential roosts. For bats, within the footprint of the scheme, I think we identified 7 roosts that could potentially be either disturbed or destroyed. And again, obviously that would be visited with the deconstruction surveys, and if there were any requirements for licenses, then that could be picked up at that point.
Thank you. And then in terms of the bat boxes that you're putting in, is that related to the number of roosts that you think are going to be affected, or is it just any suitable opportunity? I suppose what I'm asking is there a replacement policy in the same way that it is for the trees?
So if there was, but at the minute it's just they're sitting under the footprint, and then we could have a better idea whether they would be disturbed, destroyed, or maybe for for construction methods or something like that. That might mean we actually decide we wouldn't actually be disturbed even within 30 years of works. But if any were to be lost, then that would be a clear commitment to replace.
And is that covered by the bat boxes that you were talking about, or some other mechanism?
That would be, yeah, so that's as an extension, so that's provided, but within the mitigation section, it does clearly state that if any roosts are lost, these would be replaced with bat boxes.
Thank you. This may not be your area of expertise, but if not, perhaps you could direct it to somebody else in the council. So some of the objectives have obviously raised concern about displacement of vermin through the vegetation clearance. I don't know if that's something that's been assessed in
Yeah,
the
I
new
think-
area or elsewhere.
Yeah, that, I believe it was something that was assessed in the EIA, but it's certainly something that, you know, we have, you know, I've experienced it on other similar schemes. You know, we are working in urban areas, and you know, vermin is a common occurrence, and we accept that there is that possibility that we could disturb in our rats. And we have seen that happen on other projects, but I think what we've committed to is that you know, we would engage the council's environmental health officer to determine an appropriate kind of vermin control plan, which may involve, you know, kind of implementing measures before any construction works are take place, but also kind of committed to working on a kind of reactionary basis that, you know, if someone hopefully an unlikely event that, you know, rats don't get into people's houses, but if they did, you know, the council would engage that kind of pest control services at no cost to the property owner. But I think it's, you know, we're working in an urban area on water courses, and yeah, it's seen it on several projects occur, but it's been dealt with in a similar manner to just described there.
Thank you. I think that's all my questions on that, because we'll be moving on to the detail, the site element and picking up on the birds that you mentioned. Unless there's anything on other ecology. Right, if we can move on then to part B, which is the designated sites and habitats regulations appraisal. Before we move on to the substance of that, I think we've obviously had a little late email which I accepted from RSPB, but I think Mr. McMurray, you wanted to comment on evidence and things. You pointed that out this morning. You wanted to make a point about this.
Yes, no, it's just that if there was an email sent by the council on this correspondence and making the case as to why it shouldn't be accepted. I don't know if I should see that correspondence. I can restate those points for you now, or I can leave it there. But
It's entirely up to you if you want to repeat them. I saw the email. I understand the council wasn't happy about the email. But I felt that it was supporting the motions that had already been submitted. If you want to make any other points about it, now is the time to do it.
no, ma'am, also as a matter for you, if you're happy to accept it, then the council will accept that decision, and you've got the council's comments on the way that could be attached to it. I'm happy to go there.
Okay.
There was one other sort of procedural matter in relation to the HRA or administrative matter, I should say. There's a document which RSPB that have referred to in their statement, and it's heavily linked in the Asia Scott guidance which RSPB have provided, but the actual document itself hasn't been provided. There was one extract that we thought would be helpful for you and for the hearing today, which might help short circuit some of the discussion, particularly around whether or not compensation measures could be located within a designated site itself, and it's the European Commission guidance on habitat regulations. But I just thought I'd raise that at this point.
Is this a document that so you're saying it's a document that RSPB have referenced?
Yes, referred to in their statement, and also heavily linked in the Nature Scott guidance, which they have provided, but the underlying guidance is not provided.
Are you content? Do you need a break to just check that it is a document that you're familiar with? That are you suggesting that you're providing a copy, or?
Yes, we have hard copies here. It was literally just an extract of, I think, 1 or 2 pages. Rather than watch the whole document, it was just the relevant part to make people's lives easier as much as anything.
What I'm going to propose is if we maybe just break for 5 minutes, and then if you two just have a wee chat to make sure that you are happy that it is the document that you've referred to and that you've got a copy, and then we can proceed from there. Is that everything?
kind of high level alternatives, such as, construction of a tidal barrier across the River Forth, but, that's not, from an, purely even from an economic kind of perspective, that's not going to be a viable solution because you're looking at, a cost in the region of billions of pounds to implement that, which, doesn't really stack up. So that was kind of ruled out as an alternative. I'm just trying to.
I suppose it's maybe just worth pointing out the do minimum, do nothing, do minimum, do something options that were looked into. The do something option that was taken forward was the only option that actually met its scheme objectives. And that in itself demonstrates the alternative from that perspective.
Thank you. And I wanted to give RSPB a chance to come in here. Were there other alternatives that you felt should have been considered? That I'm conscious we're trying not to move into the litigation with the timing of construction sort of flips between the two, but
I think that's absolutely right. Thank you. And I think the two are so intertwined as to what it's quite difficult to extract what's mitigation and what's alternatives. In this case, I think are question marks, and I think it's fair to say question marks were around the viability of working out with the out with the key wintering period for birds, and whether that's classed as mitigation or an alternative. I think, and I think it's fair to say we felt that the information in the original documents didn't provide us with sufficient confidence that that being looked at, and those that had been looked at as a kind of methodology. Well, could that be done? And I think also, if I'm able to say, we would like to see that whilst we perhaps accept that there may have to be for the scheme to be viable, equally that is a significant mitigation or to work out with the wintering period, so that whilst we understand that even if for the port's functionality to go ahead, or for the operation to go ahead, it could still be a potential condition or some kind of mitigation for it to be, wherever possible, that work to take place at the key sites out with that period.
thank you. I wonder if I can turn to Paul Ports here, because you've also raised the question of alternatives in your hearing statement. And I suppose I'm really wanting to understand the position that you're coming from in terms of looking at alternatives, because you've suggested alternative locations for the wall to include these areas of land that we talked about this morning. Whether you feel that those are alternatives that should have been included as part of the FOCA assessment.
We absolutely do, and if I could just start off, I mean, the agenda item was referring to the relationship between the HRA and scheme design, and therein lies a sort of fundamental point, which is that we feel that the HRA has, in terms of being made publicly available to help inform scheme design, come very late in the day, and we set out our detailed arguments that we don't agree with council's view that there's no requirement to undertake and make available an HRA as part of the scheme notification process, that procedural part of the overall procedure, and we think it really should have been made available much earlier to help inform the ongoing design process through the product of consultation, and that is the normal procedure for major projects like this. And we also actually believe that not making the HRA available earlier than it was means that consultation was not effective either, because to consult effectively and lawfully you have to make relevant information available, and the HRA is quite clearly relevant. But that's a sort of a starting point. I think the our response to the written statements, so that's the 12th of January document we put in. I think the point I just made is summarised there in 2.25. But I think our overall position is that the council has failed to account in the HRA for the option of realigning the flood defence wall the way that we say it should be realigned to protect those developable plots for the future development. And we say that undermines the alternatives they've assessed and therefore how they've got to their EROP case. And we also think that, I mean, the council has accused us of engaging in speculation. I think that they've also themselves made very speculative comments, but the point is they haven't assessed, it's a fact, they haven't assessed the alternative that we say they should have assessed, and had they done so, then it may well be that its conclusion on compensation, for example, could have been accommodated within the bounds of what they're being put forward, within the bounds of what they're putting forward, if a greater degree of impact on the SAC were to be the conclusion of their assessment. So we think that even if the scheme is not amended, as we say it should be, we think that and I can come back later to deal with that optionality point you mentioned this morning, because we've been giving that some thought, but even looking at the current scheme as proposed by the council, we think the HRA is flawed for the reasons we've said, because it doesn't consider what we think is a very viable alternative, which is to expand the scheme in the way we've said it should be expanded. So that's essentially where we're coming from on this. It's obviously quite a detailed issue that we set out in detail in our written statement of the 12th of December.
Thank you. Could I ask the council if you'd like to?
Sorry, 16th of December, I meant.
If you would like to respond to that point about whether the HRA should have considered these other options that have been put forward in terms of different locations.
If I could first of all just address this procedural point made there, the council's position, and I'm sure will be accepted by the store, there's no requirement for public consultation on the habitat regulations appraisal, notwithstanding that the council has consulted, well, not just with Nature Scott, but with the wider public, and copy was sent to both ports who didn't respond to that consultation. Now the council is making no point in relation to that, because both ports have an opportunity now to comment and participate in that, but there has been a consultation on the HRA, which both ports chose not to respond to. As matters relate to assessment of alternative solutions, the requirements for the purposes of HRA is to look at or to consider alternative solutions, but where those alternative solutions are likely to have a greater impact on the site and the conservation objectives of that site, then they do not constitute a feasible alternative solution. And perhaps let Ms. Murray to provide some context as to why the alternative put forward by both ports would not constitute a feasible alternative in the context of HRA.
Through the HRA process, we've consulted with Nature Scott to try and minimise the impacts on the SP, and that has resulted in design changes to reduce footprint within the SP itself, and for example, temporary habitat loss came down quite notably, and permanent habitat loss came down a bit as well. But so that was all done try and minimise the impacts on the SP. So as it stands, we have potential adverse effect on site integrity for disturbance to 11 species of birds at high tide roosts. If we were to look at some of the proposed changes to the design, then we could be looking at additional adverse effects on the SPA, that could include habitat loss, which currently is not one, could include more birds being disturbed. In the energy park area, I think the defences could move up to 200 metres, and that's obviously going to bring many more birds within the potential zone of influence that we use to make our assessment, and that would impact roosting birds and also potentially foraging birds, because that could push the zone of influence much further into the estuary. It's maybe also worth just pointing out that we can't, obviously we haven't done an assessment, so we can't really jump to what the conclusion would be of these alternatives, but we can't really assess them because we don't know the specific alignments. We don't know what those types of flood fences would be, and all of that then also impacts potential encroachment on the ASP and potential disturbance. So, a line doesn't really help us conduct a sufficient assessment. We need a lot more information to do that.
Could I also just add that in terms of alternatives, the route option 4C within the appropriate assessment is a shoreline option. So that was taking the defences along the shoreline, but was ruled out based on what Spinny's just said, and also it didn't, I think from memory, didn't achieve all the scheme objectives, but that is noted in the HRA and the appropriate assessment.
Stuart, did you want to come back briefly on that?
Just very briefly, I don't quite understand that point we made about lacking information, because we certainly put forward in a number of different places what we think the realignment should be, and in terms of the kind of structures that realignment might involve, then it's perfectly possible for the council to make some assumptions sufficient for the purposes of conducting an alternative assessment as part of HRA. And indeed, I think I've seen some comments in the council's response to our statement saying, oh, well, this would require larger revetments, etc., etc. So they've clearly already done the work now to assess what the physical consequence of our proposals would be. So I don't quite understand why it's felt there wouldn't be enough information to feed that alternative into the HRA.
Again, I could just for clarity on that point, Mr. McGowan said that the alignment of being on the edge of the bank has been assessed within the HRA, and I think it's important to remember the context of the reason and the effects, which is giving a rise to the ability to conclude no adverse effect on site integrity, and that is disturbance to the species. And as Ms. Murray said, that the kind of alignment with the subcases blue, the defence is up to 200 metres, which would bring a lot more birds into the zone of influence. So it has been assessed in terms of the HRA. I think what Ms. Murray's point is it's not possible to conduct a fairly detailed assessment to the extent as the design is within the scheme. So the alignment would suggest that approach has been assessed. It has been ruled out for the reasons stated within the HRA itself, which is the detailed assessment to the same extent that
Okay, thank you, everyone. I think I've got sufficient on that, and I'd like to move on to mitigation and turn to RSPB first of all. So perhaps you'd just like to summarise for me why you think there hasn't been proper consideration of available mitigation. We've talked about the timing, but I don't know if there's other aspects that you feel perhaps could have been addressed further.
Thank you. We're just noting as well that under paragraph 6.3 of the council's response to RSVP statement, I think there is an acknowledgement that a bit more information on this aspect would have been useful in their documents. And yeah, we appreciate the additional information that's given in the response statement. And yeah, appreciate the complexities of the issues around this. So yeah, we are mindful of that. And the council's commitments to avoid operations in the wintering periods, that's October to March inclusive, if the scheme goes ahead. And as Toby had mentioned before, we certainly welcome that those commitments and commitments on phasing and not doing certain phases at the same time were secured in condition if it wasn't possible to avoid the wintering periods. Absolutely.
Is there anything further on mitigation that you wanted to bring to my attention? No. Any comments from anyone else?
It was just to acknowledge and welcome that absolute and to thank the RSP for acknowledging that.
If we can turn then to the third element, which was the compensation, and I believe that you're concerned about the compensation measures which are being proposed to address the adverse effects on site integrity that have been identified. So could I first of all start, I suppose, I'm going to ask the council to start by just summarising what the compensation is and then perhaps come to RSPB so that you can clarify for me why you feel that's insufficient.
So I was just thinking to see if you could pick this one up. Yeah, it was Mr. Nathan, pick this one.
So as stated, the adverse effect is for disturbance to or potential disturbance to high tide risks. And through consultation with Nature Square early on, we agreed that it would be best to have the compensation as close to the potential disturbance sites as possible, just to limit the potential energy expenditure of birds. And we identified two sites, one at Boskenner Pools and one at Peel Lagoons. So Boskenner, there is an area of land between the two pools, which we think the compensation proposals would basically do a little bit of vegetation management and slightly change the area of land in between the two pools to increase the edge habitat, just to make that more attractive for roosting birds. And then some of the vegetation management would be slightly profiling that bit of land between the two pools, removing some weeds and rushes to improve sight lines so that birds feel safer to use that area, and also to give them more area to actually use as a roosting area. That's the general sort of habitat management proposals for Boskenner and Camille. Lagoons, the proposal is to create 4 islands in the lagoon. So that one of the sort of proposal started with 1 island, which would be there's a spit of land there just now that's made of concrete and rubble, and that material would basically be repurposed into an island with a channel to prevent any predators or dogs, etc., getting onto that. And then through discussion with Nature Scott and review of data, that has increased to 4 islands, just to ensure that we're confident that the compensation proposals are robust and there's more than enough roosting habitat at both sites. There's also a little bit of management of vegetation at Camille proposed as well, again to improve sight lines, remove potential predator perches nearby. But yeah, the primary compensation would be the 4 new islands within the lagoon that would act as roosting habitat, and then additional measures like volcano, just to ensure that there's two options for the birds, and that links back to the sort of two key areas of high tide roosts. One which was at the Breakwater, which is just west of the port, so those birds would be closest to Volcano. And then the other large area we call within nature Shelter Bay, which is just north of the petrochem plant, just in sort of a corner next to the land what's called that the Grange land, so in that little corner there. And so those birds would be closest to Canadian Greens.
Okay, thank you for summarising that. So if I can turn to RSPB then, do you want to sort of summarise for me your concerns about the compensation?
Yes, thank you. If we maybe just summarise and then perhaps pick up specific points, we need to go into detail. So as you'll be aware, one of the reasons about having the designation as an SPA is to maintain a kind of coherent network of sites, functional sites, across the UK and Europe. And so one of the, obviously looking at the impacts within both the fourth SPA, the use, we have particularly concerned about the location of the two compensation areas, particularly being within the SPA itself. One of the principal concerns that we have is that both sites currently suffer from levels of disturbance. Within the HRA itself, Falkirk Council kind of admits that a really important part of any roosting site, which is, we accept is the kind of key element here, or the key issue here for birds, is that they are safe from levels of disturbance. And we, from our own experience and in consultation with local bird watching community, we're well aware of that both Kinneil and Bothkenna pools, so the sites where compensation is being proposed, do suffer from very significant levels of disturbance. So that's, I suppose, a primary point. I think our secondary point is much of the compensation work that's being proposed, we believe could be being undertaken by Falkirk Council as a public body under its duty for SSIs under the Nature Conservation Act, so that they should be undertaking these works anyway, and as a result of that, they shouldn't be then kind of offering us up as compensation. And we think particularly at Bothkenna pools that's the case.
That's I have a question, and I'm just trying to find the right page. So I think in your hearing statement, paragraph 615, find it, you've listed, just going back to your first point about the compensation areas all being within the boundary of the SPA, and I'd be keen for you to explain to me a little more why you feel that that's inappropriate. But I just wanted to pick up on this paragraph 6.15. You've quoted there, I think, from Nature Scott's European Site Casework Guidance, and you've included 3 bullet points from that, setting out sort of a summary of what compensation sites might be. And the 3rd bullet point says restoration of non-qualifying habitat to qualifying standard on this or another site. So I'm just trying to understand why you feel that the selection of sites within the SPA boundary is not compensation, and if that's what you're thinking, why it doesn't meet that 3rd bullet point, I suppose.
Yes, thank you. And I think just to clarify, it's probably fair to say that we're not saying that all of it isn't compensation. I think there's certain elements of the compensation offered in terms of the non-qualifying habitat. So there are particular parts of Bothkenna pools, so which is in its entirety within the SPA, that where work is being proposed to be done. we feel that it is actually kind of qualifying habitat, or should have been qualifying habitat, and that so again, that we have issues with that. We feel that there's already qualifying habitat where proposed compensation is being proposed, and that's also the case at Kinneil Lagoons, where the islands are being proposed. One island in particular, where is, as Ms. Mooney says, is currently, let's say, non-functional, but some of the other islands are going to be put on functioning habitats for, in this case, not, well, roosting, but also feeding birds as well. So some of the proposed compensation is being put on functioning habitat.
So if I'm understanding correctly, what you're saying to me is that the two sites that have been identified as compensation habitat already support some of the qualifying interest features, and that the measures being proposed, in your view, are not compensation because those birds are there already. It's not actually increasing capacity, if I could put it that way.
I think that's true to an extent, and I think it's also highlights some of our concerns with undertaking compensation within SPA itself, is that you come up with this issue where you're potentially trying to do work on site that within, is within the SPA itself. So you're trying to slightly tweak functioning habitat to maybe make it better, but actually, we have issues with this on both sites, and it already is functional habitat. Maybe pass on to Colin.
And just in terms of the complexities of potentially doing works within the XPs, potentially having those kind of knock-on effects on other aspects of the XP, which and yeah, I don't know if you want to say anything else.
Possibly just elaborate on that. One of the issues with islands is that, so as you may be aware, the birds that we're kind of considering tend to like clear lines of sight, so they like to be able to see large areas around them, particularly at roost, and that's a kind of essentially a predator aversion. They like to be able to see predators coming. If you put islands in a feeding habitat, that can interfere with those lines of sight, which is in the what some of the work that being proposed at Bothcan Pools essentially accepts that and is moving towards opening up those areas. So it's a kind of bit of a change at Kinneil. Potentially with these islands, you're putting new islands on functioning feeding habitat that may affect both roosting and feeding birds.
Thank you. And just before I allow the council to come back, so just if I can draw you back then to this third bullet point under paragraph 615, which is talking about restoration of non-qualifying habitat to qualifying standard. Your argument is that some of that, or its habitats are already would support the qualifying interest features. So it's not functioning at the moment. It's already functioning, so it's not an additionality.
I think that's right.
Okay.
And that's just sorry if I may just clarify that we're not saying all of it is, but elements of it.
Okay, thank you. Could I ask the council to respond to that then, this concern that the habitat that's been proposed is already supporting qualifying interest features and therefore it wouldn't represent compensation in that respect?
Thank you. The third point I would touch on is just the point about I think point you raised around the compensation being within the SPA. I think if you look at the additional document that we submitted, there is a paragraph in the middle of the first page of that, page 68, which actually says that actually locating compensation within or near the site is actually not only permitted but the preferred solution. So and there is case law to support that as well, but I wouldn't intend to dwell on that. As for the compensation measures being part of what the council should be doing already, the council is very clear that the compensatory measures that are being proposed are in addition to any sort of site management that they are either planning or required to do, and that's just needs to out in the response to the hearing statement. In terms of the functioning habitats, I'll defer to Ms Mooney to provide a response on that.
It's acknowledged that some birds do use both sites already, but suboptimally, and I think RCB also acknowledged that in their written statement, particularly about Kenner, due to habitat being overgrown, that's probably impacting the bird use of the site. So both sites are currently suboptimal for the birds, and our proposals are going to make them more suited specifically to support high tide roosting birds. This is sort of compensation for, and this is what we're focused on. And maybe make things about it, but with regards to Neil, the point that the habitat is already being used by birds in the islands would actually remove some of that functional habitat. You know, this is I think in relation to the late information that was submitted from the WEB's data collector. Now, we checked our data when that came in just to be confident, and whilst birds are using Kenner lagoons for foraging, they're not using them where we're proposing to put the islands. The preferred areas are to the southwest and to the north of the lagoon, and that's our data shows really strong aggregation of birds using those areas, and that really nothing under the footprint of where our islands would be. So the provision of islands at the lagoons will provide the high tide roosting habitat that is, specifically for compensation for this project, but it will not impact the preferred areas for feeding for those birds. I think there's quite a long thing. I think there's maybe a few other points we might want to.
Was there something else you wanted to bring up? Sorry.
Possibly at some point we can maybe deal with the issue of disturbance and the roosting, but I'm not sure if it's necessarily that's interesting.
Yeah, that fine, carry on. Yeah. You want to? Yeah. Well,
thank you. That's okay. Yeah.
Yeah.
So obviously we talked about some of our concerns about undertaking some of the work within potentially functioning habitat. The other, again, significant concern we had, which started out with, was the issue of disturbance at both the roost sites. Where we have currently, we have, I suppose, three, you might describe as three key roosting areas of Grangemouth itself, the hard defences, the existing hard defences around Grangemouth and some of the salt marsh habitat, which functions as a roost, and off Kenner pools and Kenner lagoons. And we have concerns that essentially what's being proposed with the compensation is, let's say some disturbance to one of those key three, and all have a function in a way. That's why birds use that site. We think it's particularly notable that birds use Grangemouth slightly perversely, although with lots of bangs and whistles at Grangemouth, but actually it's a relatively undisturbed site, particularly for dog walkers and kind of access. So what's happening in this scenario is there's disturbance to one of these three key roosting areas, and the compensation is being provided in two other already existing roosting sites. And we think that really increases the vulnerability of the sites, because particularly to disturbance, where currently you have three sites that birds could potentially relocate to if there was a disturbance instance as one or even two. And what we're essentially doing is the compensation is being proposed to enhance two of those three sites, but not provide a third one. So we're losing a kind of functional area to move to should the birds be disturbed. And they are regularly disturbed at both, as I say, Kenner and Both Kenner, and you might get some natural disturbance at Grangemouth currently.
And just to sort of follow through that thought, obviously it's not RSPB's role to do that, but are there alternative options, do you feel, for compensation in terms of providing sites which would be accessible, which I think is what reason for the selection of the sites, I've been told.
Yes, thank you. Yes, we have, throughout this process, talked about potential alternative sites. Slightly echoing Port's comments, one of the things we felt is that these two sites were decided on very early in the proposal, and I say, sorry, these sites, just to reiterate, both Pools and Kinneil for the compensation, and indeed, it was noted that Nature Scott had already agreed that these sites were suitable back in 2019, so quite early on in this process. RSPB's done an awful lot of work in this area. We, as you'll be aware, and it says in Appendix 3, we have a reserve, our skin plants reserve at Bucks, Grangemouth. We've also done work over the past 20 years to identify a number of enhancement projects throughout this area, including things like managed realignment, which could create exactly this kind of alternative compensatory habitat. And indeed, again, as you've seen from our written statements, we have historically tried to work with Falkirk Council on at both Kinneil and Both Chemicals and developed management plans that didn't come to fruition. So yes, sorry, that's a long-winded way of saying yes, we have identified a number of alternative sites.
Just in terms of the issue of it, the compensation measures being proposed within the SPA, I think we've never said that there was a kind of rule against doing that, or it never was done. But just, yeah, sort of still digesting the document that we've just got today, and we certainly welcome the opportunity to kind of comment on that after the hearing, if that is possible, just when we've had the chance to look at it. But just noting that it seems to say that, the site and compensation within a Natura 2000 or a European site, if where suitable conditions for the measures to be successful, seem to be the preferred option. And I think that's our concern there, as Toby's can outline, is that there are issues with those sites. So yeah, just the ecological coherence, that's the kind of the factor that we're kind of concerned about, and the specific instances in this case.
Thank you. Could I turn to the council? And I've got two questions for you. The first one is in relation to this, the replacement, as it were, in terms of, we've talked about trees this morning, this afternoon, one-to-one replacement or 1-to-3 in certain areas. In terms of identifying alternative sites for compensation, did you have a number in your head? Was it 1-to-1 or 1-to-2, 1-to-3? And then secondly, if you could pick up on the point from RSPB about alternative sites, or there might be additional for alternative sites to give a third option, as it were, to any of those that are disclosed.
So the work that has been put into these compensation sites has happened over a number of years, and looked at carrying capacity and things like that at the sites. So it's our position that the two sites is actually very robust, and it wasn't necessarily two sites for two roosts, and that's obviously better. But I think our data suggests, and our calculation suggests, that even one site would or should support the birds. I think it's maybe worth just stepping back slightly and maybe elaborating on how the potential disturbance, how likely that is. So the HRA is very precautionary, and that's obviously underpinned the process. From all of the work we've done, and that includes noise monitoring, observing birds during GI works and things like that, there's been next to no disturbance observed by our ecologists during GI works along the estuary edge. For example, from some GI within the port, we recorded sort of 8 to 8 potential disturbance events, and there were only 3 times where birds actually flew up, and they flew less than 30 meters away, so they did not leave the site, and that didn't have any noise or visual barriers in place. And in other instances, they've had noise monitoring where there's been birds on the breakwater about 150 metres away from where they're monitoring, and they didn't react to GI works. So we've got a lot of information that really suggests the birds are used to some level of the activities in an industrial area, that they're used to a lot of it. We're really not, from our work that we've done, we really haven't found strong evidence that suggests large numbers of birds will fly away during the works, but causation is underpinned by the precautionary principle, but obviously ensuring that there's compensation in case the birds are disturbed. So in terms of also, we also look at noise and visual disturbance. In terms of noise disturbance, the work we've done identifies that noise at the bird would be an acceptable level about sort of 45 metres from the point of disturbance for the noisiest activity, which would be the embankment construction. So anything less than that, the birds are going to be, from a noise perspective, there really shouldn't be that much disturbance. So we have a precaution zone in sort of 300 metres for noise disturbance. So that's really built in quite a large buffer there. So I just thought it was worth kind of highlighting that with them. We're talking about birds being disturbed. We've acknowledged the potential of birds being disturbed, but it's really highly unlikely that it's going to be large flocks of birds flying up and going large distances. All the information we've got is that they're either not going to react or they'll move short distances, but nonetheless the compensation is there should that happen. In terms of considering other sites, so there were some considerations early on. The area referred to as the Grange Brownland, that was one that was initially considered. That does fall within the zone of influence. It's also not pocket trains of land, so there would be no guarantees that land being available for use when we needed that. There are also some concerns around potential contamination, and that area is also quite high, so there's a number of factors there that that one wasn't really taken much further forward. Yeah, it's acknowledged that the two sites were settled on quite early on, but that was because there was a lot of discussion with Nature Scotland. We wanted to ensure, due to the fact that they are within the SPA, that they were comfortable with those sites, and we've continually revised the designs to make them stronger throughout the years. In terms of looking at anything further afield, when there's two sites there that were identified and are suitable, looking at something further afield is only going to increase the energy expenditure of the birds, which move against the whole principle of the two sites we've identified.
So anything you want to come back on there?
Thank you. Yes, just a few points if I may. Firstly, I absolutely accept that birds can habituate it to industrial work, movement of vehicles, particularly. Birds are very bad habituating to people movements. They react and tend to be disturbed at much greater distances and a much greater extent if they see visual people walking on mud flats or close to mud where they're roosting. And roosting is a particularly key point at which they are vulnerable to disturbance. And just in terms of the distances mentioned about when they suffer disturbance, what's really crucial about these high tide roosts is that they are at high tide, so that they don't have these alternatives to move to. So, it's one thing to say, well, you only experienced it at, say, 50 metres, but actually at a high tide, that they don't really have much more than 50 metres to roost to. Looking at some of the kind of cumulative issues, we are seeing increasing, particularly recreational disturbance to high tide roosts across the Firth of Forth. So the existing routes are becoming more and more important and kind of really critical, particularly and around the Grangemouth area was really a key site for that. So if I may just make that point, the other thing is, whilst we accept that there's some, at least anecdotal assessment, or at least recognition of potential disturbance of some of the GI works, it doesn't appear that there's any assessment of disturbance on the potential compensation site. So there wasn't any disturbance surveys, there wasn't any, and again, looking at the levels of disturbance, an industrial, someone undertaking GI work, although it might be more noisy, actually someone with a dog off a lead going on a footpath could cause much more disturbance, or particularly a wildfowl, than a kind of industrial process. So I think we don't really accept that the surveyors didn't see any disturbance on the sites, and that means there wasn't disturbance, and particularly looking at the compensation sites. And just on the point of energy expenditure, the point about, they need to be able to go to a site close to nearby the Grangemouth. I think the crucial point is the bird move along the estuary. What's really important for them is to be able to go from a feeding habitat, so the mudflats, to a roosting site. It doesn't necessarily mean that they need to go the shorter distance from the existing roost at Grangemouth to another roost. So it means that the energy expenditure is, they're feeding on the mudflats, there's a disturbance, or the tide rises, then they move to a site that's nearby where they're feeding. That's the energy usage, rather than they get disturbed at Grangemouth and they need to be able to fly to another roost.
Is there anything you want to come back from this meeting?
Yeah, sorry, I just wanted to, I was conscious that I hadn't been mentioned yet, but of course, when Nature Scott, of course, approved and endorsed the approach taken by the council in relation to the compensatory measures and the entirety of the HRA, and that is also with the benefit of having the late correspondence that was submitted to you as well. They've also endorsed it and having insight of that as well. I'll let Ms. Moon comment on the technical aspects.
Yeah, I'll just maybe touch on the disturbance point. So at Keneal, there is a path along the estuary, but there's nothing that would allow people or dog walkers down close to the islands, and that terrain is actually quite difficult. We know that from trying to get some samples to the works, that it's really not easy to get to. So the disturbance at would be limited to the one path along the estuary edge. At both Kenner, there are paths to the south and to the west of the site, and discussions with Falkirk Council's biodiversity officer in the past had highlighted that they had undertaken some additional planting to improve the screening at the site, and that planting was done to the north, to the southeast, and to the west. Now, that will obviously only improve as that vegetation matures. It is acknowledged that there's an area directly to the south of the pools that has no planting currently. However, that is out with our zone of influence, so we wouldn't be expecting birds to be disturbed based on our assessment on that side of it. It's also just worth pointing on that RSP's written statement did mention both Kenner and Keneal and Grangemouth area as key roosting sites. Now, whilst our assessment didn't identify them as the key roosting sites, their claim that they are would then indicate that the birds clearly can't get that disturbed, or they wouldn't be using those as the key roosting sites. And then just to touch on the fact that there's been no formal assessment of the disturbance at the site. So whilst we had ecologists conducting the bird surveys at the site, they would note down any reasons for the birds change of behaviour, and they didn't notice a lot of disturbance from dog walkers or the like. Now, I appreciate that would have been during Monday to Friday working hours, but and it might be busier at weekends and evenings. However, the potential disturbance from the scheme would be conducted during Monday to Friday standard working hours. So the times that the compensation sites may be subject to more disturbance, the original roost locations will still be available to birds.
Is there anything further else do you can say on
No, I think just to quickly say, I think it's rather sadly, yes, there was work done by Fulford Council to try and screen it. It hasn't been very successful. So, I mean, we do a lot, and you know, I know everyone knows the site, but we do a lot of work down that area, and it's regularly the gaps in those hedges. So I'm afraid it isn't successful. And I might also just quickly add, one of the issues again that we haven't really seen discussed is that whether so definitely in you know ostensibly to add compensation to enable more birds to move to Kinneil and Boskenna, that what is being proposed as compensatory bird, that's the limiting factor, and I don't think we can necessarily say, just in your response to, well, you know, the birds are already using that. We don't know why there aren't more birds, or that they definitely could be moved. You know, if you do this work, the birds will move there. So I think it's that sense of we know that they are used by birds, but actually by increasing, you know, putting in new roosting habitat, we don't know if that's what's limiting the usage of both Kinneil and Boskenna. And the reason I'm just in response to Ms. Noonan's points is that, you know, that to that point, oh well, they're used anyway, so that shows that disturbance isn't having a factor. I think that's not necessarily the case, because we don't know if they're at capacity. So we don't know if they are at capacity and needing new roost sites, or there's something else that's limiting the number of birds there. It's particularly Kinneil is a large area and could potentially hold huge numbers of roosting birds already. So I don't know, and I think it's very difficult. We haven't seen any evidence to show that that's what's limiting it.
I think a useful point to pick up on, because it's my understanding of compensation of the HRA is that it has to be certain that it's going to deliver. And so I suppose if you can provide some comments on how certain you are that these measures you've mentioned, this compensation will actually deliver in terms of providing compensatory habitat, well, compensation for the numbers of birds.
Yeah, Boxley had a team of ecologists working on this, including lead ornithologists with years and years of experience, and they've identified that island habitat is attractive to roosting birds. They've identified that the habitat right now at both sites, obviously Kinneil, the islands don't exist. We'll be creating them, and it's concrete rubble, that's not functional habitat, so they're going to add in roosting sites for them. And at Boskenna, it's been acknowledged by multiple parties that the habitat could be improved. It's already used by some birds, and we know that they need certain habitats and certain things to align for them to use something as prepared roosting habitat. And if we know those things are not in place right now, by ensuring that they do have the good sight lines, that there is suitable edge habitat, and all these other things that would make it attractive to the birds, then there's confidence that birds already know that those sites exist, that the habitat's going to be improved and they're going to use it. And obviously Nature Scott are content that we've got enough confidence in our compensation proposals to be happy with the conclusions of the HRA and of the proposed compensation measures.
Yes, I was just going to reiterate that Nature Scott have reviewed and been involved in the development of the proposals throughout the iterations of the process, and are quite satisfied that the proposals are sufficient in their role as statutory nature conservation body.
Thank you. Is there any other points that RSPB wanted to raise? Can I just clarify that the document that was handed to me, this is referenced in RSPB's. So it's just that I wanted to pick up with Ms. Cleland suggested that she would need time afterwards to comment on it, but I thought it was a document you had referred to.
We referred to Nature Scots document, which is RSPB 13 document,
Yeah,
which in that
refers to this document, doesn't it?
So yeah, but what I'm sorry not had quite time to check is I suppose just to check that this is the document Nature Scott referred to in theirs. I'm sure it is if it's been put forward, but just to kind of give us time
All right, just to
have a bit of
confirm that it
detail.
was that document that was
Yeah,
referenced. Okay,
but yeah, I'm sure that it'll be correct, but just
okay.
giving chance to look at it. But yeah, it was just Nature Scott's one that we've actually referred to direct.
Right, I'm conscious of the time, which is 4:15. I am confident we could probably finish if people were prepared to stay till 5. I just don't know what other people's constraints are, and then that would leave tomorrow free for site inspections. I will, however, suggest that you take a 5-minute break because I'm still confident that we can do that. So let people get up, stretch your legs for 5 minutes or so, and then we'll crack on because, as I say, I'm confident we can finish this afternoon. Thank you, everyone. Thank you, everyone. I anticipate that we may well sort of be harking back to earlier conversations, so that may sort of speed our deliberations for this last section 6, which is legal and financial matters, including effects on property values. I'm going to start with the council, and as you'll be aware, there are a number of the objections have questioned the effects of proposals on property and land values. So my questions to you are, what relevance, if any, is there to the effect of the proposals on property values in terms of making a decision about the scheme? And if you want to go on to mention whether you think it would have an effect on property values, but it be dependent on your answer to the first question, really, in terms of whether you think it has any relevance today.
Thank you, Mark. I can pick this one up. Our position is that while the impacts on people and their property are relevant matters, the valuation, impacts of valuation are not relevant to the decision on whether or not to confirm the scheme. And we set out in the hearing statement that notwithstanding this, just to give a bit of reassurance to members of the public who are affected by the scheme and businesses as well, that the council has or is aware that there are compensation provisions in the legislation to deal with any impacts on value and other damages that might be incurred by people affected by the scheme. And the council has instructed the valuation office agency to help with sort of preliminary assessments of compensation, which have been factored into the cost estimates of the scheme, which have been considered to date. So we don't consider it to be relevant to the purpose of today and the council decision whether to confirm the scheme. It's just to reassure people that it is a matter which the council is very much aware of and is taking active consideration.
Thank you. And you sort of picked up on the point which I also had about compensation. And I think just again to draw on conversations earlier today, it's been mentioned to me at least twice that there would be pre-construction surveys of property, is that correct? And then a post-construction survey, so you've got some evidence base for any discussions on that matter.
Yes, that's entirely correct. I think it was Mr. McGowan who pointed that out, and that is something that the council has confirmed to many parties who inquired and raised that issue with them.
Thank you. And then the last question really, I suppose, on that related matter, which again, a number of objectors have raised, is in relation to responsibility for management of the flood defences going forward and how that's would be dealt with.
I could probably cover off the sort of general responsibility point, and I'll hand over to perhaps Mr. Dawson to talk about any detail you want to add. But essentially the position is that the council will be responsible for maintaining the defences that are constructed. Any sort of surrounding land will remain the responsibility of the owners of that land to maintain as it is currently. Council is obviously aware of partially for both folks here today who, with access to their site will be much more difficult. That's the type of matter which could be managed and dealt with in terms of agreements with folks in due course. But that's the sort of general position that the council would set out on each of those matters. And I don't know if Mr. McGowan, Mr. Dawson, have anything to add.
Thank you. And I don't know whether both folks want to add anything at that point in terms of how your role might interrelate with the ongoing management, particularly things like lock gates and so on, whether you think that's something that can be dealt with by an agreement.
Thank you, ma'am. Well, certainly, I think what we've been calling this Section 58 agreement will clearly need to cover maintenance as well as design and construction, and it may well be that the agreement is struck that the port deals with ongoing maintenance of the lock gates. I don't know. This is yet to be discussed. Mr. Heapson, if you want to comment on this briefly.
Yeah, just quickly, sorry, but there's always been discussion and expectation around maintenance and liabilities would come out in discussions. It just so happens potentially the scheme accelerating and then some of the objections that have arisen, that's not happened at present.
But it's a fundamental issue that will need to be dealt with as part of those overall discussions on legal arrangements.
Thank you. And we have probably already covered this off, but just to give forth another opportunity. In section 4 of your hearing statement, you've obviously raised concerns about this interrelationship between the flood protection scheme and how that might affect your role as a statutory undertaker and the need for this agreement. I didn't know if there's anything further that you want to. I mean, we have sort of discussed the fact that there are mechanisms to come up with an agreement, but whether there's anything else you wanted to say at this point. It was more, I was reading this, and perhaps I'm reading it wrongly, that you were suggesting that if you were not content, then there would be the ability to prevent the council from coming onto the land to do the works, and whether that was something we wanted to talk about further.
Yes, I think that we're not entirely clear, and maybe neither as a council, that's not a criticism, as to quite what sort of order these things would need to proceed in following this process, and were the council to decide to confirm the scheme, it may be that the council would wish to recommence discussions on this overall legal agreement sooner rather than later. As I explained, I do think we need to factor in the planning conditions, because a Section 58 agreement between us and the council is not a substitute for planning conditions relating to the overall scheme. That the two have to work together, because the council, the port will want to be certainly a consultee in relation to relevant planning conditions, as well as having its own direct protection in a Section 58 agreement. And one hopes, because the council and the port have a good working relationship, that the time will ever come when the port might need to consider withholding consent under section 58, but there is that ultimate backstop, if I can put it that way. The council have quite fairly pointed out that it is subject to Scottish ministers deciding if consent has been withheld unreasonably. We're nowhere near that point because there isn't a detailed proposition for us to consent to or not, and therefore I would expect these things to be resolved sensibly and collaboratively. I think that I would also, though, sort of warn against anyone thinking, oh well, fourth ports have the protection of section 58, therefore that's almost a substitute for there being an acceptable scheme in the first place. And of course, that our position is, our position as a statutory undertaking, the protection we have in consequence is not a substitute for there being an acceptable scheme in the first place. And we don't think, as I've been saying, I've got a few concluding remarks later to underline this point, that this is an acceptable scheme. So we will have to consider what happens as a result of your report and the council's decision. And the hope is that we can reach a position where we think the scheme is acceptable for one reason or another, and that, combined with the detailed provisions of a legal agreement entered into, would hopefully be enough, combined with acceptable planning conditions. So it's a really complex sort of a Rubik's cube in a way, in terms of all these things being in position in the right order and the right colour.
And the council wants to respond to that, and this relationship between the scheme and the statutory function.
Yes, thank you. I don't think I have a huge amount to add. I think Mr. Lower and I are pretty much in agreement on how the operation of section 58 would apply. All I would say was that the council has always remained open to progressing those discussions on agreement, and I welcome what appears to be coming from both ports that they would like to progress those discussions, and I think that's one positive we can absolutely take from today. The only other point I would add is that the council doesn't disagree that section 58 is not a substitute for an acceptable scheme. The council's position obviously is that this is an acceptable scheme, but the section 58 is there to deal with those points of detail once we actually can understand the precise details of the scheme. And while there is that backstop, as Mr. Long put it, of the Scottish minister, I would like to think, and I think the council would like to think, that given the relationship between both ports and the council, that an agreement is eminently achievable.
That concludes the questions that I had, everybody, this afternoon. I'm hoping that there's nothing that anybody desperately thinks they've missed out. And I will allow people to just make a couple of concluding comments in a minute. But before I do that, is there anything burning that people feel they haven't had a chance to air today? Before I come to the concluding comments, I'm just going to sort out the site inspection arrangements, if I may, for tomorrow, for fourth ports. I believe you should have been sent a list of names, and you Mr. Knox. So can you just confirm for people like me who are not familiar with the docks, where you want us to meet you tomorrow? That said the dock office, is that through a lock gate or
Office, which is the best way to go into that's off Timber Beast about off Errol's Gate Road. You'll come through the main security entrance where those that are attending, their names should be given security. You'll have to show photographic ID when you come in. So driving ID, passport is sufficient. Security will ask for that. You'll get handed a temporary pass, and then drive down to the kind of main port office in the port, which is effectively a straight road down King's Sandstone Road, and you'll see next to the containers. I can get a map sent out if that is required for anybody.
It might not get to people before
Yeah.
tomorrow's one. So you said off Earl's Gate Road.
Off Earl's Gate Road, yeah.
Okay. And what would be a suitable time for people to meet tomorrow? Would 9:30 be appropriate?
I'm flexible, I think.
I'm afraid I'm not sure. Could we move it to 10? Would that be okay? Just to
Definitely,
try and-
At 10 o'clock then at fourth ports. And I know you said PPE was necessary. Do you, I would require a hat.
Yeah, that-
Outfits and RSPB, you're okay for?
If there was one available, say, to go in the office.
Yeah.
you know, if you have-
Yeah, we've got some there. It's just more about footwear and sizes and so on. But a couple of weeks before we finish, and I'll get something. So
Right, so I think we know that he's coming from sub team, don't we? We know he's coming from fourth ports, and we've got representative from RSPB there. What, sorry, did you want to?
I was just going to make the point, you know, we've said any of us can be available, it's really up to yourself, who you would expect or would like to attend. And then
It really only means, well, I was just going to go on to explain that the purpose of it, it won't be part of the hearing. So it's just purely a site inspection. So there'll be no discussion of the merits of the scheme. All I'll be looking for is for people to say to me, this is the Grange Fern land. This is the area of land to the northwest of the site. This is where we're talking about the access in. This is where we thought the wall could be placed instead of where it is. So I would leave it to your team to decide who can do that. But I'm not going to be discussing the merits of the case at all on site tomorrow. Okay, so I'll leave it to, you know, it doesn't need people to answer technical questions because I'm just looking at genuine understanding of the site and surroundings.
Sorry to,
Yeah.
did you say, and it is just the Four Ports land itself?
Well, I was just going to turn to Mr. Gold because you mentioned about whether you would want me to come and have a look at Jarvie land. I did drive into, well, not to the actually into the yard, but I did drive down and see the locality. So I'm reasonably happy that I know what it looks like.
Yeah, that's
So if you're content, then I won't come on to your land again tomorrow. But yes, it's just obviously Fourth Ports land is restricted access, and I couldn't, when I was doing my own economic site inspection, get to see these areas that are mentioned in everybody's representations. I'm very content about site inspection. Thank you. Well, what I'll do then is I'll do a sweep down the table and enable people, if they wish to just make a couple of concluding comments about their case and their position. I'm going to start at that end of the table with Mr. Wilson and just work round and finish with the council. So Mr. Wilson, is there anything finally you want to say?
Yes, thank you. Just a few concluding remarks. I think principally I don't think we said up to this point that RSPB does not, is certainly not opposed to the scheme in principle, just to make that, I suppose, clear, and we certainly put that in our written statement. And that we want to get the best outcome for the SPA, on behalf of everyone, and particularly with our interest of having our reserve immediately adjacent to the scheme. And obviously we have really outstanding issues, concerned about the level of compensation. And if I can perhaps briefly explain how we see it, essentially at the moment it's kind of three baskets. We've got, forgive me, kind of eggs in three baskets. We feel that the compensation is looking to decant them into two that may or may not be filled and are potentially getting jiggled about. So I think that's our kind of critical issue around how the compensation is being delivered. And finally, right from the start, we've been very keen to work with Falkirk Council on this. We've got a long history of working with Falkirk Council, including in formal partnerships. So we're very keen to continue that throughout this process, and certainly if it was including identified alternative sites or just working as beyond this scheme. So we have to continue to do that as well. Oh, and sorry, and just quickly say, that would include potentially any conditions that might come out of it.
Mr. Cole?
No, nothing further to add. What we said around.
Thank you. Mr. Owen, I don't know if it's going to be you or somebody else from Fourth Ports.
I think it's me. I've got four relatively quick points, I hope. The first is I do appreciate that views differ here, but in terms of engagement, we don't feel it's been meaningful, and I think it has betrayed throughout, certainly this is the view for Fourth Ports, that there haven't really been an open mind, a willingness to discuss scheme design and alternatives, and that is a shame, we think, and it's frustrating given certainly where we've ended up now with the fourth green Freeport and a dramatic change in public policy. So we think that that has been our experience. No real open mind to discuss alternatives or indeed different elements of scheme design. Different aspects of scheme design, I should say. Secondly, this is probably the major point. Fundamentally, we're not at all sure. In fact, we don't really believe that the scheme does meet its own objectives, and we think there is quite some confusion about what the scheme objectives indeed are. The council identified that the primary outcome of the scheme is to protect communities and the industries which they support, and they go on to say that the secondary outcome is to remove a major barrier to long-term investment and facilitate physical and economic development in and around the scheme area. So those are the primary and secondary outcomes. If you then look at the objectives of the scheme, and that's document FC 012-006, those objectives include, relevantly, to develop the scheme in accordance with the measures set out in the 4th Estuary Flood Risk Management Strategy and also the 4th Estuary Local Flood Risk Management Plan to reduce flood risk at Grangemouth. That's 01 objective. Then there's 1 to increase development activity in Falkirk Grangemouth corridor, such as the Falkirk TIF initiative, that's objective 3.5. And then 3.6 is to provide a platform for the regeneration of Grangemouth. It's interesting that nowhere in the list of objectives is there a stated primary purpose of protecting only existing development. And also notably, a focus on primarily protecting existing development is not a restriction of the 2009 Act, or indeed a stated purpose of the Local Flood Risk Management Plan. So the council's objectives for its scheme clearly require a scheme which increases development activity in Falkirk and provides a platform for the regeneration of Grangemouth, as well as delivering best value for money. And these are core guiding objectives for the scheme's development. And while protection of existing development is, of course, fundamental to any flood protection scheme, it's not the sole focus. And yet it seems to us that it's been disproportionate in terms of how it's influenced scheme development and design. So we must have a choice here. We have a council-led, publicly funded scheme which will either significantly support or enable, to use the council's term, or significantly hinder future development at the port and therefore future investment in Grangemouth as a whole. And we say that if the scheme has the potential to incorporate as an enabler the port development land we referred to and deliver greater investment opportunities for the region and a greater cost benefit ratio, then it should do so. If on the other hand the scheme is going to exclude the port land we referred to, then that decision needs to be fully justified and thoroughly tested, with the alternatives put forward by the port meaningfully considered, and also the full socioeconomic costs of the council's preferred scheme accounted for, and that just hasn't happened. And as an aside on this, we've obviously talked a lot about the HRA process, and it's established practice, I believe, and indeed law, that the HRA should focus on in looking at alternatives that meet the scheme objectives, because that's a fundamental part of the HRA process. The council have said that only the option they're promoting meets the scheme objectives, but they haven't, in our view, properly assessed the alternative we put forward, which we say better meets the scheme objective than the council's. preferred. So there seems to us to be quite some confusion about that whole issue of scheme objectives, and we don't think the scheme meets its own objective. That was the second point. The third point, I'll be very brief because we've covered it really in terms of planning conditions. And this was a point I would like to stress in our written statement. We very much welcome what the council have, I believe, committed to today, which is that they will at some stage make available the draft conditions for comment. And I think that was a commitment given to all objectors, but I'll be corrected if that's not the case. The fourth and final point, we were talking this morning about what we term sort of optionality and whether there was a way for the council, they would need to agree this, of course, to, in effect, amend the scheme so that it did include the development sites we referred to, but there was only a commitment to extend the scheme to those sites or to implement the scheme in that guise if certain conditions have been met. And we're certainly not aware of any obstacle in the 2009 Act as to why that couldn't be done. And in terms of how you deal with that in HRA terms, we think the solution is actually fairly straightforward, because what you do is the scheme you would justify on European grounds would be the larger scheme. There would just be one scheme. It would be that you wouldn't be assessing two different schemes. You wouldn't be having two different schemes in terms of flood protection schemes. You just have one scheme, which would be for the larger scheme, if I can put it that way, including the development sites that we put forward, and that would be what you would justify on European grounds, and there would be a mechanism in the planning direction, probably I would say through conditions of that would set out when the scheme would be implemented in that way, as opposed to stepping back to a slightly smaller scheme if development of those sites is not forthcoming in a reasonable timescale. And I wanted also to underline the point that this assumption that the fourth green Freeport will be limited for 10 years is one that may well prove to be incorrect. As I mentioned, in England, the Freeport initiative has already been extended beyond the initial period. So these things can be extended, and indeed life doesn't end at the 10th year, because commitments entered into before that period expires can, I believe, then last for another 5 years. So I think I just encourage you to be cautious about viewing the 10-year period as an absolute period with a firm cut-off at the end, because we just don't have that certainty. And the legislation under which the fourth green Freeport and other green Freeports have been set up has that flexibility, as I understand it. So those, I think, are the concluding comments that we would make to draw out those issues in particular. Thank you.
I can turn to corporate council. Well, is it you?
Yeah, thank you, Emma. I will be as brief as I can. I don't want to prolong the day any longer. I would start by just pointing out the scheme itself is the largest flood defence project in Scotland, one of the biggest in the UK, and has been identified by CPAT and the Scottish Government in 2015 as the #1 priority flood protection scheme in Scotland. To give an indication of the scale of the scheme, around 10,000 parties were notified of the scheme through the service of statutory notices, and prior to scheme notification, the council undertook extensive engagement with the community, and that's reflected in the documents FC 005-001 to 006. And when placed in that context, it the success of that engagement consultation is reflected in the number of parties that have objected to the scheme, given that number, and the concentration of the location of those objectives as well helps to reflect that. I think the council would like to point out, as set out in sections 1 and 2 of its hearing statement, which and I won't rehearse it, but that there is a strong policy support and compelling needs case for the scheme. And it's noteworthy there is actually a limited challenge to the need for the scheme in the objections and by all those parties who receive notification. Taking all in some of the points made by Mr. Owen, the council doesn't agree obviously with engagement, but it set its position out, and I won't reiterate that in the interest of time. As to the additional land and modifications put forward by both boards, again, the point I made earlier, I'd like to reiterate and just emphasise that there is no land use designation or allocation for any of this additional land, nor any planning permission or even application for planning permission. And I think Mr. Knox himself referred to it as an aspiration. That being said, confirmation of the scheme without these modifications does not preclude development on these sites should Forthcourt be able to make a case for it, nor does it prevent or preclude the ability of flood defences in the future to protect this land should the case be made for those developments. And as I pointed out earlier, not all flood defence works have to be done by a flood defence scheme. It is possible to do these works by agreement if that can be reached between the parties. On the point of optionality in the scheme, again, I would just reiterate the points I made earlier, around optionality, and we think that would undermine entirely the no alternatives case made in the derogations case for the project. So we do not see that as a viable option to deal with the proposed modification put forward by both boards. And overall, generally speaking, in terms of the HRA derogations case, again, just to emphasise that Nature Scot, in their role as statutory nature conservation body, having been involved in the development of the case throughout, have endorsed the work that's been done by the council and its consultant team, and are quite happy that there's a case that can be made to support derogations based on the habitats regulations. And on the basis of the matter set out in the council's hearing statements and the evidence given today, I would respectfully submit that the scheme should be recommended for confirmation. Thank you.
Thank you, everyone. I know it's been a long day, but I appreciate everybody's contributions and for your willingness to carry on just a little bit longer so that we could get the discussions completed in the day. So thank you very much. I produce a report, it goes to the council and they make the decision. Thank you very much for coming, and at 10 to 5, I will call the hearing to a close.
Thank you, ma'am.